India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court has said that Allahabad High Court will monitor CBI probe in Hthras gang rape case. Request to transfer the trial out of UP has been left open until the investigation is completed. And in a setback for Lalit Modi, Supreme Court stays a Bombay High Court order on BCCI. Cross-examination of BCCI official as demanded by Modi will now not happen. The Supreme Court will hear on November 2nd plea seeking a standard operating procedure to be adopted by the Chartered Accountant exams by the Institute of Chartered Accountants of India this year. And Bombay High Court gives relief to private hospitals, says state government does not have power to frame laws regulating treatment rates charged by private hospitals for non-COVID patients.
India Legal presents Courts Roundup.
Responsibility. The Supreme Court has asked the Allahabad High Court to monitor the ongoing CBI probe into the Hthras gang rape and murder case. As regard the plea for transfer of trial outside the state of Uttar Pradesh, the CJI-led bench stated that the question of transfer is left open until the investigation is completed. The bench also took note of the submission of the Solicitor General of India that the order passed by the Allahabad High Court had disclosed details about the victims and her family members. Based on that, the court requested the Allahabad High Court to remove the facts disclosing the details of the victim and her family from the order.
The Supreme Court has ordered that all aspects of the Hthras gang rape case would be considered by the Allahabad High Court. The bench of Chief Justice of India, S.A. Bobde, and Justice A.S. Bopanna and V. Ramasubramaniam also refused to comment on the merits of the case in its order. The order was passed in a batch of pleas praying for an independent probe into the shocking gang rape in Hthras, followed by the police alleged forced cremation of the victim's body in the dead of night without the consent or presence of her family. The petitions and applications that were taken up for hearing together also prayed for the trial to be transferred out of the Uttar Pradesh, preferably to Delhi. Another request made was to ensure adequate witness protection for the victim's family. The court had earlier sought to know from the state of Uttar Pradesh the steps taken on the aspect of witness protection. In its affidavit filed in response to the question, the state government gave details on all the security arrangements made for the victim family, coupled with the installation of CCTV cameras. Some interveners urged the court to direct the deployment of Central Reserve Police Force (CRPF) personnel for security on the ground that the state police was accused of having a role to play in the incident. While the Director General of Police (DGP) did not oppose to the request, it was prayed that should the prayers be allowed, a message should not go against the state police. The UP government had maintained that it is not treating the case as an adversarial litigation. The court was also told that the family had chosen to engage 2 lawyers to represent them, but had requested for a government lawyer to also be appointed. This submission was made in the affidavit after it was alleged in court that the soliciting of legal services was being done by some lawyers. The order on these issues was reserved on 15th October. Pertinently, the Allahabad High Court had taken suo motu cognizance of the midnight cremation of the victim. During the course of the hearing before the Supreme Court, the bench headed by CJI Bombay had also mooted as to how the scope of the case before High Court can be enlarged. It also opened that the case must be heard by the High Court first. Bureau Report.
An application has been filed in the Supreme Court seeking urgent hearing of the pending challenge to the electoral bond scheme. The application, filed by Association for Democratic Reforms through Advocate Prashant Bhushan, seeks to highlight the issue which involves corruption and subversion of democracy through illicit and foreign funding of political parties and lack of transparency in all accounts of all political parties. It states that an urgent hearing is needed in the case in light of the upcoming Bihar election. The last hearing in the matter was almost 9 months ago. ADR further states that the window of selling electoral bonds was not opened earlier this year but was opened in October right before the Bihar polls. The petitioner has sought to strike down certain amendments made through the Finance Act 2017 and the earlier Financial Act 2016, which were both passed as money bills. Substantiating the need for an urgent hearing, the application states that the Bihar election approaching, the electoral bonds issues needs adjudication. The amendments under challenge have removed the existing cap of 7.5% of net profit in the last 3 years on a campaign donation by companies and have legalized anonymous donations. In January, the Supreme Court had declined to grant an immediate stay on the implementation of the electoral bond scheme ahead of the Delhi Assembly election. The application referred to investigative reports which suggest that the Reserve Bank of India had repeatedly opposed amendments to the RBI Act and the Finance Bill 2017 as well as the electoral bond scheme. The Supreme Court has observed that courts should inform the accused of the availability of their indefeasible right to avail default bail once it occurs to them. The objects of Section 167(2) of the Code of Criminal Procedure are subsets of the overarching fundamental rights guaranteed under Article 21. The bench, comprising Justices UU Lalit Mohan, M. Shantagodar and Vinit Sharan, said in the judgment. The bench also observed that if the court deliberately does not decide the bail application but adjourns the case by granting time to the prosecutor, it would be in violation of the legislative mandate. The court said that provision of default bail is for ensuring a fair trial, expeditious investigation and trial, and setting down a rationalized procedure that protects the interest of indigent section of society. Referring to the decision in Rakesh Kumar Paul versus State of Assam 2017-15, SCC 67, the court observed the court also reiterated and that the issuance of notice to the state on the application for default bail filed is only so that the public prosecutor can satisfy the court and that the prosecution has already obtained an order of extension of time from the court, or that the challan has been filed in the designated court before the expiry of the prescribed period, or that the prescribed period has actually not expired. The prosecution can accordingly urge the court to refuse granting bail on the alleged ground of default, the court said. The court also deprecated and that the practice of the prosecutors filing additional complaint before the concerned court to defeat the indefeasible right of the accused to be released on bail. And we are now joined by Advocate Shivam Sharma for more update on this.
That the counsel for the accused as well as the magistrate ought to inform the accused of the availability of the indefeasible right under Section 167(2) once it accrues to him without any delay. The public prosecutor cannot be permitted to misuse the limited notice issued to them by the court on bail. Application filed under Section 167(2) by CRPC by dragging on proceeding and filing subsequent application for the purpose of buying extra time. The court also observed that the right under Section 167(2) would be rendered nugatory as the investigation officers could drag their heels till the time the accused exercise his right and conveniently files an additional complaint including the name of the accused. Yes.
Thank you, Shivam, for the update. Moving on. The Supreme Court has sought the responses of the High Courts of the preliminary reports to submitted by the emissary query with suggestion that expeditious trial of the check bounce cases under Section 138 of the Negotiable Instrument Act 1881. A bench comprising Chief Justice of India S.A. Bobde and Justice L. Nageshwar Rao passed the order in the suo motu case in re-expeditious trial of cases under Section 138 of the NI Act. The court also sought the responses of state police chiefs of all states regarding measures including coercive steps to ensure the appearance of the accused in check dishonor cases. Senior advocate Siddharth Luthra, one of the amicus curiae appointed by the top court, told the bench that a preliminary report was submitted on October 11. He added that only 3 high courts, the high courts of Rajasthan, Madhya Pradesh and Sikkim, have responded to the report. The court also asked the high courts to give their response to the draft scheme formulated by the NALSA, and the DGPs of various states may give specific suggestion in response to the report, particularly with reference to the service of summons and coercive process of the accused, the order stated further. The matter will be listed after 4 weeks, and it was on March 7 this year that the bench of CJI Bobde and Justice L. Nageshwar Rao registered the suo motu case to devise methods for expeditious trial of Section 138 NI Act cases, a matter which is supposed to be disposed of summarily by the trial court in 6 months. It took 7 years for this case to be disposed of at the trial court level. A dispute of such nature has remained pending for 15 years in various courts, taking judicial time and space up till this court. The Supreme Court has observed then. And in a setback to fugitive cricket boss Lalit Modi, a 3-judge bench of the Supreme Court headed by Justice R.F. Nariman today stayed a Bombay High Court order of 2019, which was in favour of Modi. The High Court has also asked ED to consider afresh the request for giving Modi the reply of BCCI to their show cause notice in 2011. Solicitor General Tushar Mehta prayed for a stay on behalf of the ED, which was granted by the bench of Justice R.F. Nariman, Navin Sinha and Krishna Murari. Modi had sought a cross-examination of official of the Board of Control of Cricket in India in connection with a case of alleged FEMA violation. In that order, the Bombay High Court had asked the Enforcement Directorate to consider the case afresh, giving Modi the reply of the BCCI to their so-called notice in 2011. The cross-examination will not happen now. Modi had moved the Bombay High Court in a petition under Article 226 challenging the decision dated 21st August 2017 and 8 January 2018 of the Director of Enforcement as an adjudicating authority under the Foreign Exchange Management Act 1999 and Foreign Exchange Management Adjudication Proceeding and Appeals Rule 2000. His grievances to order dated 21st of August 2017 was to the extent it rejects his application for a copy of the reply filed by BCCI main notice in the show cause notice dated 20th of July 2011, which is also issued to him. So far as the order dated 8 January 2018 is concerned, the challenge was to the extent it declines to grant cross-examination of 5 persons, namely and the Supreme Court said that it will hear on November 2nd a plea seeking a standard operating procedure to be adopted by the Chartered Accountant exams by the Institute of Chartered Accountants of India this year. The CA exams for this round are scheduled to begin on 21st of November. The bench of Justice A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna heard the petition filed by some CA aspirant today. The petitioners have claimed that with the exam scheduled to begin in less than a month, ICAI has not taken adequate steps for holding of the exams in line with the health guidelines issued amid the COVID-19 pandemic. The court asked the petitioner, represented by Advocate Bansuri Swaraj and Asta Sharma, to serve a copy of the plea to ICAI and the centre. The matter will be heard on November 2nd, and earlier a PIL had been moved before the Supreme Court, assailing ICAI's notification of an opt-out option for CA aspirant. The present plea says that the concerned authorities have not taken steps for assuaging the health concern of the stakeholders. The plea says that a significantly higher number of candidates are expected to take the exams in this round on account of the May cycle of exams standing cancelled. This fact, along with the cap of 100% for congregation imposed by the Union Ministry of Home Affairs, give rise to the concern of the petitioner. It is further pointed out that an option for candidates to change their exam centres within the same city is not provided as yet. The institute had decided that in the interest of the candidates, it would merge the May 2020 exam attempt with November 2020 examination. Now let's look at the online initiative of the Supreme Court. One such initiative is E-Committee. The E-Committee website was launched by the chairperson E-Committee, Dr. Justice D.Y. Chandrachud, Judge of Supreme Court of India, on 29th of August 2020. Supreme Court's E-Committee aims to provide citizens with easier access to information about the online initiatives taken by the court across the country. Justice Chandrachud, the chairman of the E-Committee, launched the website via an online event. The termed the panel as the arm of the Apex Court under the E-Court projects. At the command, the E-Committee website aims to put forth the initiative taken under the E-Courts project. The Citizens Corner provides for number 1, a list of citizen-centric services, 2, integration with other government departments, 3, manuals. Under citizen-centric services, a user can access the link and details of various e-court services such as virtual courts, e-courts, fee payment, NJDG, High Court. On the E-Committee website, there exists a dedicated page for the High Courts, where the links of all the High Courts have been provided. The High Courts will upload the initiatives taken in connection with the E-Court project and will showcase the best practices adopted by each High Court. This will help other High Courts to pick up the best practices and implement them in their High Courts. It will also pave for healthy competition among High Courts to work towards excellence. The Madhya Pradesh High Court has observed that an advocate getting enrolled under Section 24 of Advocates Act 1961 can be subjected to further condition before he is permitted to practice as an advocate in court. The writ petition were filed at the instance of advocates provisionally enrolled with the Madhya Pradesh State Bar Council. Apart from challenging Rule 9 of All India Bar Examination Rules 2010, they prayed before the court in that direction be issued to the Bar Council of India to declare the result of the centre of Jabalpur and Bhopal of the examination conducted on 15 September 2019. This Rule 9 was challenged in the writ petition filed before the MP High Court on the contention that it is beyond the competency of the Bar Council of India to frame such rule, which tends to deprive advocates who are enrolled under Section 24 of the Act of 1961. However, the court also noted that the right of the Bar Council created under Section 24 has been made subject to other provisions of the Act of 1961, for example, Section 49 of the Act. The court observed that while on the one hand, Section 30 of the Act of 1961 makes provision as to the right of advocates to practice, on the other hand, Section 49 confers on the Bar Council of India the general power to make rules for discharging its functions under the Act of 1961. And the Bombay High Court imposed a hefty fine on social worker accused of assaulting a doctor and abusing medical staff of the hospital after the COVID patient's death. And the bench of Justice Bharti Dangre directed the applicant accused to deposit an amount of 1 lakh rupees in the CM Relief Fund. The court also clarified that failure to deposit the amount would denude him of the protection from his arrest, and the applicant accused was booked for the offence punishable under Section 452, 323, 504 and 506, 509, 269 and 270 of the IPC, and also Section 2, 3 and 4 of Epidemic Disease Act 1897. The complainant, Dr. Sujit Atsul, in this matter lodged a complaint to the effect that on 10th of September 2020, Dr. Rahul Jadhav telephoned the complainant and informed that one of the patients who was infected with COVID had died and people close to him were creating ruckus in front of the hospital. The accused questioned as to how the corona patient died, and he assaulted him by fist and also abused staff of the hospital. This resulted into the filing of a CR, the family members being in the deep sorrow due to the demise of their near ones. The applicant argued before the court and that he might have overreacted, but now he bewails. The court observed that the sorrow and grief of the family members of a patient who was entrusted in the care of the hospital staff could very well be understood. However, the court said it also cannot be forgotten that in the turbulent times of the COVID-19 pandemic, it is the doctor and the nursing and health staff who have acted as corona warriors, had been savior of the infected persons. And in what may come as a significant economic relief to private hospitals, the Bombay High Court has held the state government does not have the power to frame a law or issue notification regulating rates chargeable by the private hospitals to non-COVID patients, and quashed 2 state government notifications fixing rates applicable to non-COVID patients in the private hospital healthcare providers. Division Bench of Justice P.V. Ganendiwala and Justice R.K. Deshpande at Nagpur were hearing a writ petition filed by Hospital Association Nagpur and Dr. Pradeep Arora challenging the said notification issued by the state government, which contained the following clause. The said notification fixed maximum chargeable rates for both COVID and non-COVID patients. Petitioners had challenged the relevant clauses fixing rates for non-COVID patients. Previously, in an order dated 25th of September, the same bench had stayed the operation of said notification and asked the state to clarify its stand regarding state's power to issue such notification regulating rates chargeable for non-COVID patients. The bench concluded that the said notification are an encroachment over the fundamental rights of the petitioner under Article 19(1)(g) of the Constitution of India to practice any profession or to carry on any occupation, trade or business. Finally, the bench quashed and set aside the notification. The Allahabad High Court has expressed concern over frequent misuse of the provision of Uttar Pradesh Prevention of Cow Slaughter Act 1955 for implicating innocent person. While hearing the bail application of one Rehemuddin, accused of cow slaughter and sale of beef under Section 3, 5 and 8 of the said Act, the single bench of Justice Siddharth observed this. The remarks were made after the bench was informed that the accused applicant had been in jail for over a month, even when allegedly there is no allegation against him in the FIR. It was also alleged that the applicant was not arrested from the spot. Thus, considering the material on record, the court allowed the applicant's bail plea on his furnishing a personal bond and 2 sureties, each of the link amount to the satisfaction of the court concern and subject of the other bail condition as prescribed. And that's it for Courts Roundup. Thank you for watching.
Presents Courts Roundup.